You've watched a trial on television and you hear the attorneys making objections. What are those objections, and what are some of the most commonly used objections? During the course of a trial, attorneys on either side can often make evidence objections, objections to questions, or sometimes objecting to something that should not be said in front of a jury. One of the most relevant, or if not the most relevant, evidence objection would be relevancy itself. Objecting to relevant evidence is essentially saying that the evidence the other side is presenting is not relevant, that it is nothing to do with the facts of the case, and it does not go to prove or deny the claims in the case. While all relevant evidence is admissible, relevant evidence can be inadmissible if it confuses the jury, if it causes delays in trial, if it's cumulative. Say a party has already entered that evidence and they're trying to enter more evidence on that same fact, that could be considered cumulative and thus would not be admissible. Another objection that's most often used is objection to improper character evidence. So during the course of a trial, you can't present evidence that on a particular occasion, this person acted in a particular way to show that is their character, essentially. A common way that this can be used is saying like, oh, this person is a thief, so he must have stolen on this occasion. Character evidence can't be used like that in a court of law. Another one that you probably have all heard, especially now after the Johnny Depp trial, is hearsay. Hearsay is a statement made outside of the presence of the court that is being offered for the truth of the matter asserted. So what does that legal jargon mean? Essentially, it's a statement that is not being said by the person testifying. So if I was testifying, it would be like me saying, Bob told me blah, blah, blah. And I am trying to say that to prove the truth of whatever Bob had told me. That's hearsay. And hearsay is inadmissible. Now, there are exceptions to hearsay, but I believe there are like 37 of them, so I won't get into them today. But typically, hearsay is inadmissible when you're trying to prove the truth of something. If you're just trying to say Bob said something just because Bob was saying something, that's a different matter. But when you're trying to offer that statement, somebody outside of the court said, to show its truth, can't come in. And finally, one objection that we typically see in cases of sexual assault is a victim's sexual history is typically inadmissible, and that's to protect the victim and to protect their rights. There are certain cases in which sexual history or sexual conduct can be admissible, but that's very nuanced and I won't get into it in this video. In addition to victims' rights being protected, there's also spousal privilege and attorney-client privilege that can keep information from coming into court. The next time that you're watching a trial, look out for those relevant objections, the hearsay objections, the character evidence objections, and see if one side or the other is trying to protect spousal privileges or attorney-client privileges. You'll probably see a lot of them. Thank you for watching. If you have any questions or comments, you can leave them for us down below, or you can find us online at versestexas.com.